Good afternoon.
Good afternoon.
Good afternoon.
Hello, Judge.
Hi there, y'all.
Your Honor, Rebecca Martinez is interning with my office. She is just observing with me today.
Okay, welcome.
Good afternoon. Thank you.
You bet. Mr. McKeska, would you please begin the announcements?
Yes, Judge Brent McKeska, attorney for the department.
Sonia Sims, I'm the attorney for the child and movement for today's motion.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the child.
And Julie Pike, Hill Country Casa guardian ad litem for Tyler.
Your Honor, placement, Miss Dacia Woodfox is also present.
Hello.
Good afternoon, Ms. Fox.
Good afternoon.
All right, Mr. McKeska, I don't see your caseworker here.
Judge, I was texting her right now, but to be honest with you, I think we can move forward without her if she's not able to join.
Okay. Ms. Sims, as stated, is the movement for the motion for the progress hearing. As a recap, back on May 1st, we were discussing the holdup to moving forward with the permanency goal, which is the fictive kin adoption. Ms. Rogers had testified she was working with someone from Mr. Murr's office. She had concerns about getting the social security number, or there were concerns about getting the social security number. And she had testified that there had been several attempts to reach out to Vital Statistics. And we're basically here today, according to, I'm sorry, I don't know how I muted myself. That was an accident. Anyways, did anybody hear any of that recap?
We heard everything, just the last part. We're here today.
Okay. We're here on your motion to figure out where we are. There was a pleading that was filed. It was rejected. There's been, as at the time of the filing of the motion, which was July 3rd, so 15 days ago, there had been no movement on that. So, Mr. McKeska, without Mr. Rogers here, what can you tell the court about the progress with that?
So, Judge, the petition for the delay birth certificate was actually refiled on July 3rd under cause number 24478B. Initially, Judge Kelly's court, or Judge Kelly, actually rejected the filing, said that he wasn't the appropriate court. We refiled it. It was refiled in the county court of law. So there's some issues that we had to go through with the district clerk's office to make sure that it was assigned to a district court. That way it would fit the requirements under the statute. It could be referred over to you. So actually today, the only thing that I'm missing are the actual instructions on how to fill out the court order. So I know it's very specific about color of ink, the way the handwriting is on the form, those sorts of things. That way we could actually get that order completed, get into your hands and signed, and then filed with the clerk.
Okay, so that referral to this court has been done?
Well, whether or not the cause number has been referred directly to your court, I don't know. But we do have a cause number in the 198 for the petition for the delayed birth certificate.
Okay, so then my question is, there's a standing referral order for all CPS cases to this court. I guess my question is, does that standing order to refer to this court cover this particular cause number?
Judge, I would argue that it does, since that this petition for delayed birth certificate comes out of the original filing in the suit affecting the parent-child relationship.
Okay, so then your argument is that I do have jurisdiction over the subject matter and the child based on that cause?
I do, Judge. I mean, because if if it weren't for the way that CPS cases are referred in Kerr County, had this original cause number been filed with the 216th or 198th, we wouldn't have had to file a secondary petition to get it specifically into a district court.
Ms. Sims?
Your Honor, I hope that works. I am just eager to have the order so that you can sign it and we can move forward. The adoption has been greatly delayed, and this is just the first of several steps that we need to continue working on to finalize the adoption today. Is there a setting to have the order signed? I know you're waiting on instructions, Mr. McKeska, on what color ink and what format that order needs to be signed, but can we put some deadlines on it to keep it moving forward?
I mean, I think that I don't have it pre-marked as an exhibit, but the supporting documentation I could share with the court right now, and we could actually have the court make the findings and issue the order today. I just need to fill out the physical order. I can't remember how many copies there were supposed to be. I have copies of the actual form because it has to come from Vital Statistics. I have them from a separate case, but I believe there's instructions that went along with it that I don't have. And so I just need those instructions in order to make sure that it's blue or black ink and that the handwriting is acceptable.
Okay, okay, thank you. I've got screen share enabled if you want to pull it up and let us take a look.
Thank you, Judge.
Thank you.
So, Judge, this is the medical data worksheet and supporting documents that were originally submitted with the request for the delayed birth certificate, indicating that Tyla's birth was on December 9th. So in conjunction with this application, there's also an affidavit from Sandra Seavey, who, if you recall, was
I remember.
witness and part of the underlying case where she has sworn that the child was born at approximately 3:25 p.m. in Mart, Texas. I believe that she was there for the birth. And then also an report from the Mart Police Department on December 9th of 2020, indicating that he had made contact with Miss Thornton and was actually able to see the baby, was able to see Tyla at that time.
Okay. What else is in this document? It looks like it's 20 pages.
Yeah, so the other or requests or applications for benefits by Miss Thornton during the course of her pregnancy. I believe there's multiple applications for SNAP benefits or for other benefits. Sorry, not just SNAP. Again, indicating that she was pregnant. And again, this was the packet that was submitted to DSHS originally. The mother's worksheet for the child's birth certificate again indicated where the child was born, the time and date, including the mother's name, the child's name, not only the address where the child was born, but also again indicating that her address was at 309. And so based on the documentation that was contained in this application, I believe it fulfills all of the requirements of the court being able to issue that order for the child's birth certificate or for the birth facts.
Okay, and what is the statute that you're relying on for the court to make the findings today?
Yes, Judge, it is. Sorry, let me pull it up. I didn't have it written down specifically. Can I stop sharing, Judge?
Yes, you may. Thank you.
So it is section 192.027 of the Texas Health and Safety Code.
Ms. Sims, do you have anything else to add?
Just that I can verify that all of those documents have been compiled by the department, and I believe they are true and accurate and properly reflect the accurate birth date of the child Tyla. And I would support the court making a finding to that today so that the order can be submitted to vital statistics and the request for birth certificate completed.
Do you have the petition available, Mr. McKeska, for me to see?
I do, Judge. Give me just a moment. Let me pull it up.
No problem.
I know it's a little bit grainy, but it is file stamped from July 3rd, 2024, with the cause number and it being filed in the 198th.
Okay. Could you scroll down slowly for me? This is their form. This is their form from VBS.
That is correct, Judge. This is a copy from VBS regarding how the petition should be structured.
Okay, and then did that petition include, there's some supporting documents here in the statute, a statement of the state registrar?
It did, Judge, and I don't know if whenever I pull different things up, can you see that on the screen now?
I can.
Okay. So this was filed along with the petition regarding the letter from Vital Statistics regarding the denial of the application.
Okay.
And then the medical data sheet, Judge, that I shared was there were several attachments that were rejected due to their size, but they were the documents that I previously showed the court.
Okay. It looks to me like that is everything that the statute requires. Would you agree?
Yes, Judge, I agree.
Ms. Sims?
Yes, I agree.
Okay. I don't really need to hear any other testimony based on what I've seen. Do you want to admit that?
Yes, Judge. I'll mark it and submit it as petitioner's one.
You can submit the entirety of what you've shown me today as
Yes,
petitioner's
Judge.
one. And then I think Ms. Sims, I'm assuming you have no objection.
No objection.
Okay.
I hate to step in where I'm not legally whatever, but on that last form, it said that her purported date of birth was 12/2. Is that going to be an issue?
So that was one of the issues regarding the denial because there were discrepancies on what date she was born on.
Okay.
And even to the point where the original order of termination reflected a birth date of 12/2. We filed and the court signed an order of nunc-pro-tunc correcting her birth date. And even with those changes, the Bureau of Vital Statistics continued to deny the application.
Okay. I heard you saying you were going to submit that again. And it's like, well, which date are we going with here? Anyway, I hate to step on toes, but I was like, oh no, we need this to happen. All right. Thank you.
That's a good question, but part of the process of the 192.027 registration is that there has to be a 192.026 statement of the original rejection. So that's part of the proof there is that the date was wrong and that was part of the issue. So it makes sense that would be in there, but that's a good question, Ms. Five. Thank you. Okay, then based on what I have seen today, pursuant to chapter 192.027 of the Texas Health and Safety Code, the petition which has been presented by the department in Ms. Rogers' name is sufficient and fulfills the requirements of the statute. And the court has also admitted into evidence petitioners 1, which not only includes that petition, but also pursuant to 192.027C, a statement of the state registrar, which was issued under section 192.026, which was the rejection, and the documentary evidence submitted to the state registrar in support of the application, which is also admitted pursuant to petitioners 1. So based on this evidence, the court will make findings as to the person's date and place of parentage as presented. I don't know if you want to put that back up there so I can read it into the record.
Yes, sir. I will put it. Give me just a second. Zoom has changed how things are pulled up.
Yes, it has. So the person's name is Tyler, and you're asking the court make a finding that her date of birth is December.
That's correct, Judge.
Court shall make that finding, and the place of birth and parentage, the court finds that to be also pursuant to this document, which Mr. McKeska is displaying on the screen for. And the court will find further that she was born at 3:34 in the afternoon on December to Brandy Lynn Thornton, a single mother. I don't know that the other finding that I'll make that I believe to be required by the case pursuant to the statute is that this order is reasonable and necessary due to the original rejection and the fact that the child was subject to a delayed birth certificate by being born at home and not registered. And the court will enter this order. Mr. McKeska, let's just make sure, and I know you already have it in the form prescribed and furnished by the department to establish a record of birth. And the order needs to include the birth data that I've just stated on the record, a description of the evidence presented today, and the date of the court's action, which will be July 18th, 2024. And the statute requires that no later than the 7th day after which the date of the order is entered, the clerk shall forward the order to the state registrar, and the state registrar shall register the order, which is going to be the record of birth. Anything I failed to address?
No, Judge, I just asked, are you going to be in office tomorrow?
I'll be available if you need me.
Okay, Judge, we'll make arrangements for me to meet you so I can get you to sign this, and then I will personally drive it out to Kerrville tomorrow.
Okay, I won't be in Kerrville. I can probably meet you in Bernie.
That works, Judge. I can come by your office.
Okay, and then the court also will make the findings that it has jurisdiction over the subject matter based on the referral of CPS cases, which is a standing referral from the 198th Judicial District Court of Perk County to the Child Protection Court of South Texas. And the court will also find it has jurisdiction over this child based on prior proceedings. This is the court of continuing exclusive jurisdiction. I think that covers it all.
Thank you, Your Honor. I think
You're
we have the star of today's proceedings that has joined us for verification of her birthday.
Hi.
Hi.
I'm glad you're here. We're working real hard for you over here.
Okay.
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 Thank you.
Thank you.
You're so welcome. Who you got there with you? Who's in your hands? Who is that?
Is that your baby? What is it?
Wait, a beer.
All right. Well, that's you and that bear are the most important participants in this hearing today. I just want to make sure you know that.
Okay, thank you.
All
Thank
right.
you.
You're welcome. Bye-bye. Thank you all for your time and your service. That'll be the order of the court. Nothing further. All parties are excused. Have a good afternoon.
Thank you, Judge.
Thank you, Judge.
Sir, on the Samsung, could you please remove your hat? Thank you. For an adversary hearing, I'm not going to take announcements because we have some issues with attorneys. I'm not 100% sure that they got notice of this, and I've reached out to those attorneys and I haven't heard back. Well, actually, I just heard back from Ms. Harris, who represents the children, and she doesn't believe that she got notice. So I don't know. There was a glitch somewhere. Court is going to reset. The court finds good cause to reset this hearing and extend the emergency orders to July 30th at 11 o'clock. July 30th at 11 o'clock. And that'll be on the Tuesday docket. I've got all the parents here, but unfortunately I don't have the attorney for the mother. And I don't know if Miss Salas has even had the opportunity to talk to Miss Fuller. Miss Salas, can you unmute, please?
Yes.
All right. Well, I do apologize, but I don't know that your attorney received notice of this setting or the fact that she represented you. you haven't spoken to Miss Fuller at all, have you?
I spoke to her the last time we went to court and she was there, and I haven't talked to her or heard from her since about 2 weeks, about a week ago when I lost the kid. She called me and was like, what happened? And I told her, and that was the last time I've ever heard from her. I've been
Okay.
sending her messages. I've been trying to stay in touch.
I understand. I appreciate that. Obviously, there's been a breakdown in communication because that's unlike her. So I'm going to reset this. I do apologize for any delay, but I want to give you the opportunity to speak with your attorney before we move forward with this hearing. So the court is going to extend the temporary emergency restraining order and is going to reset it to July 30th, which is a Tuesday. Correct?
July 30th.
Yes, July 30th, which is a Tuesday at 11 o'clock.
All right.
So
Thank you,
all
sir.
parties are ordered to be back here, and there's a Tuesday docket Zoom link. So Ms. Salas, Mr. Hines, and Mr. Aponte, please make sure that you get that Zoom link from either the department, Mr. Rabago, or from your attorney, and report back at that time, okay?
Yes,
I
ma'am.
request that you put Mr. Aponte and myself in the breakout room.
Sure.
Thank you.
Anybody else want to talk to their client? Mr. Rudkin, do you need to speak with your client?
Sure.
Okay. All right, give me a moment. I have to recreate these rooms. Everybody else is excused. I'll see you on the 30th at 11 o'clock. Do you all need to confer in a breakout room?
Yes, I think just briefly.
Sure.
Kendall County for via Zoom and YouTube. Are there any objections?
No.
No.
No, yeah.
All right, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McCaskill, attorney for the department.
Cynthia Ravago, caseworker for the department.
Kurt Rudkin, attorney for Timothy Hines.
Deborah Fuller, attorney for the mother. Miss Salas, could you unmute and announce? We're
Hi.
ready. There she is.
Conception Salas.
We're ready, Your Honor. You can mute yourself again, Miss Salas.
Lana Pearsall, attorney for Mr. Aponte. He is not present, but he was present at the last 262 setting, and I am ready to go.
For Harris, attorney ad litem for the children, I'm ready.
Sarah Woods, Hill Country Casa, guardian ad litem for the children.
We are here today for an adversary hearing. Ms. Salas has appeared today and was also served personally July 8th. Mr. Hines and Mr. Aponte both made an appearance on July 18th. Mr. Hines is not with us today. And Mr. Rudkin has had no opportunity or ability to contact him. So he is not going to be a party to this order today. Mr. Aponte, however, will be. Mr. McKeska, would you please read the agreement into the record?
Yes, Judge. Parties agreed that the department will be named as the temporary managing conservator, and Mr. Aponte and Ms. Salas would be named as temporary possessory conservators. We're asking the court to order the parents to attend a family group conference to develop a family plan of service that's narrowly tailored to address the reasons for removal in this case. In addition to the FGC, the mother has agreed to continue to participate in her services through Mindful Innovations and continue to submit to random drug testing. Parties have agreed for the parents to remain with the paternal grandparent or the paternal grandmother of the oldest children, the Hines children, and that the children won't be moved from that placement without agreement of the party or further court order. With regard to visitation, parties have agreed to weekly visitation for 1 hour supervised by the department, and that the mother will also have weekly, supervised telephonic contact with the children twice per week. During the course of our discussion, Judge, it was discovered that there is a child support order issued out of the 216th Judicial District Court of Kerr County, Texas, under cause number 22408A. And the department is urging an oral motion today to transfer and consolidate that case from the 216th into this cause number in the 198th. And the parties will submit an agreed order transferring and consolidating that case. In that case, Mr. Aponte was ordered to pay Miss Salas child support in the amount of, I believe it's $488 per month. Let me just get the actual number for you, Judge. Yeah, $488 per month. So we're asking the court to enter an order today suspending the child support payment under that 2022 cause number, and then issuing a new order for Mr. Aponte to pay the child support in the amount of $488 per month directly to the placement, and that those payments would start on August 1st of 2024 and be due and payable on the 1st of each month thereafter. I believe that is it.
Ms. Fuller, is that your understanding of the agreement? You're muted.
We also asked for the 262.013 finding, Your Honor.
Yes, Judge, that's also agreed to. I apologize for that, leaving that out.
That's it, Your Honor. Thank you.
Thank you. Mr. Rudkin, we're not making an order as to your client today.
Correct.
Am I correct? My notes say that he did enter an appearance at the last hearing. Was he did appear?
At the last hearing, he did. He was online.
Okay. But you haven't had a chance to discuss any of this with him.
He's been moving target.
Okay, and he's incarcerated?
No, he's not. Not that I'm aware of. He wasn't when he entered his appearance a couple of weeks ago.
Okay. All right, Miss Pearsall, is that your understanding of the agreement?
Yes, Your Honor. And as of the last time I talked to my client, that is what he wanted.
Okay. Ms. Harris?
Your Honor, I think that the drug testing also includes alcohol testing.
For the mother? Ms. Harris, if it helps, you can turn off your video so we can hear you better.
Thank you, Judge. I think that the drug testing includes alcohol testing.
And we're in agreement with that, Your Honor.
It's the non-issue then. Casa?
CASA is in agreement.
Thank you, Ms. Woods. Ms. Salas? Can you unmute, please? You heard the agreement?
Yes, sir.
Is this the agreement that you had an opportunity to discuss with your attorney?
Yes, sir.
And do you understand what's expected of you?
Yes, sir.
And were you forced to enter into this agreement in any way?
No.
Were you made any promises or inducements to get you to agree to it?
No.
And are you asking the court to approve your agreement today?
Yes.
Ms. Rabago, you would be giving testimony?
Yes, Judge.
Do you believe that this agreement is in the best interest of the children?
Yes.
And do you believe it's reasonable and necessary, and that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled?
Yes.
Do you believe that remaining in the home would be contrary to the health and welfare of the children?
Yes.
And you believe that the urgent need for protection required the immediate removal of the children, and that you've made all reasonable efforts under the circumstances and providing for the safety of the child to return the children home, or
Yes,
to
sir.
eliminate the need for removal?
Yes, sir.
And you believe all reasonable efforts were made to return the children home, but there's too much of a risk to do so?
Yes, sir.
Okay. And the current placement is safe and appropriate, meeting their needs?
Yes, it is.
Do the parties stipulate to the reasonable efforts made by the department in this case?
Yes, Judge.
All right, then the court finds that it has service on the mother and Mr. Oponte, and that they have appeared either in person or through their attorneys and agreed. Court finds that the agreement of the parties is in the best interest of the children in this case. Court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child, including a danger, which was caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances of providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court finds that the parties have stipulated to the reasonable efforts specifically made in the affidavit filed in this suit. Court finds that the agreement of parties is in the best interest of the child. The court will consolidate cause number 22408A into this case from the 216th in Kirk County into this cause number 24479B in the 198th Judicial District Court of Kirk County. Court will name the Department of Family and Protective Services as the temporary managing conservator of the children of this suit. Name the mother Concepcion Salas and the father Juan Aponte as the temporary possessory conservators of the child of this suit. Court makes no orders as to Timothy Hines today. We will take up any of his rights at the status hearing on August 21st, 2024 at 9:30. Court finds that court orders the parents and the parties to participate in a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the children into this case. Court finds that the mother has already agreed to participate in services through Mindful Innovations, including random drug and alcohol testing. Children are to remain placed with the maternal grandmother of the Hines children, and they will not be moved without agreement or order of the court. Court finds that it's in the best interest of the children for the mother to have weekly visitation for 1 hour supervised by the department, as well as supervised telephonic contact with the children 2 times a week. Court is going to suspend the child support payment currently ordered for Mr. Aponte at this time. Court will order that Mr. Aponte pay $488 a month directly to the placement starting August 1st, 2024, and being due and payable on the 1st of each month thereafter. The court will also enter a finding that the agreement of the parties pursuant to Chapter 262.013 is not based on any agreement of the mother to find that the allegations are true. The next hearing, as I stated, will be status hearing August 21st, 2024 at 9:30. I have to admonish you, Ms. Salas, that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do that within 12 months, your rights to your child are subject to restriction and or termination. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay. Well, I appreciate you all working out the agreement. And I think if we run into any issues with that child support, just please communicate about it. And if there's anything that I can do, any clarifying order I can make to get around whatever walls we might run into, please let me know. Be happy to do that. Anybody need anything else?
No, Your Honor.
Okay. Thank you all for your time and your service. If nothing further, all parties are excused. Ms. Salas, good luck to you. Mr. McKeska, do we need to call this or just reset?
Judge, I think we just need to reset it. I know Ms. Ortiz has reached out to both the district clerk. Well, the district clerk doesn't have the return citation. They referred her to the sheriff's office. She called the sheriff's office, and they sent her to the voicemail of the deputy who's responsible for issuing the citations or executing the citations, and hasn't heard back from them. So at this point, I think the only logical conclusion is that we don't have service on the respondent mother.
Mr. Saldivar, or Miss Acevedo, did either one of you have any contact with anybody?
Judge, I first notice that I got was I believe the investigator sent me out the contact information for the parents. We hadn't received the pleadings at that point. We just got the pleadings yesterday, like around 4 or 5 o'clock. So I haven't been able to make contact with anybody. And so I was going to ask for a reset myself. I didn't know that parents weren't served, but just because we got them so late, I wasn't able to visit with the children.
Okay.
Judge, I'm in the same boat. I just received mom's information and I reached out. There was no response.
All right. Then we're going to reset. I've got a couple hearings I set on July 30th. I'm out next week. And Judge Morris is covering, but she doesn't do adversaries, new cases. So we'll reset to July 30th at 11:30. And then the court will, this is a court order services case, right?
Yes, Judge.
Yes, Judge.
Okay. All right. So we'll reset to July 30th at 11:30. I have another case, that adversary that we were talking about earlier, Ms. McKeska, that's set at 11. You know, we might just have to be flexible that morning and just trying to figure out where to put these cases so that I'm not putting them so far out since I'm out next week. Okay. Then if you give me a reset order, I'll sign it and that'll be it.
Later.
Did you see where it's got? Can you click on breakout rooms, Mr. Hernandez?
Judge, I'm sorry. I think I got Miss Flores in the breakout room. I was asking for Mr. Hernandez if we could.
Yes, I put Mr. Hernandez in there, but he hasn't clicked on it. And then Miss
okay.
Flores asked to be put in there with you for some reason.
Okay, that's fine. Thank you, Judge.
Okay.
Mr. Hernandez, can you please hit the breakout room button?
I don't have a button on here.
Let me see. Does anybody know how to do it from the mobile device?
It should be at the bottom of the screen. If you like touch your screen, the little menu at the bottom should pop up. Or actually, it might be at the top for joint breakout rooms. They just did an update, so I'm trying to remember.
Yeah.
Mr. Hernandez, do you see it?
No, sir. I don't have that option on the bottom little.
So mine's on the top left. It says join breakout room.
I think we're talking to you want Mr. Hernandez Jr. And I think who we're talking to is Mr. Hernandez with FESS. And Mr. Hernandez Jr. was frozen and we just lost him.
Oh, okay.
So let's see if we get him back.
Okay.
In the meantime, if you want to have a discussion with Miss Flores, she's in there.
Okay, I'll go back, Judge. Thank you.
You're welcome. Savage, could you meet me back in room 1? Mr. Saldivar, I'm going to put you in there too.
Yes, Your Honor.
If all the attorneys could please click back into room 1.
Judge, the court was or the jail was contacted for Mr. Hutchinson, so I think they are going to get him on.
Okay. Well, I'm going to get going and then hopefully they can get him in time. If not, we're just going to come back as to the fathers. At all in the 454th Judicial District Court of Medina County, Texas. The court is broadcasting from the Kendall County Courthouse via Zoom and YouTube. Are there any objections?
No objections.
No, Judge.
All right. With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department.
Desiree Flores, FPSS supervisor.
Richard Saldivar, attorney for the father Gabriel Hernandez. He was on earlier. Judge is not here now. I'm going to announce not ready just because he's not here.
Kathleen Savage, attorney for the respondent father, Mr. Hutchinson. I'm going to announce not ready, Your Honor. No contact. I had made arrangements with the jail, so hopefully they can get him on, but he's not here yet.
Javier Hernandez, family-based worker.
Rochelle Acevedo for the mother. Miss Murguia, can you please announce?
Ms. Murguia, could you please announce your name?
Oh, I'm sorry, Crystal Murguia.
Thank you.
Yes, sir.
Christina Berciaga, Child Protective Investigations out of Medina.
Procedurally, we are here for an adversary hearing. Records show that Mr. Hutchins was served. However, he is incarcerated, and Ms. Savage has had no ability to contact him or get in contact with him. He may or may not appear as we go through this case this morning. He's not here yet. And then Mr. Hernandez was not served at all. He was here and we lost the connection. So at this point, I'm going to grant the not readies on behalf of the fathers, and we will not make any orders as to the fathers today. We will, however, address their rights at the status hearing September 10th at 2 p.m. Mr. McKeska did request that if the parties had an agreed order as to one or both of the fathers, if that could be submitted in lieu of a hearing, that would be fine as long as everybody signs it. And everything is in place to get them going so that we don't need to come back to court for that. So today we are only taking up Ms. Murguia's case. Mr. McKeska, my understanding is the parties have an agreement as to the mother.
Yes, Judge.
All right. Would you please read the agreement into the record?
Yes, Judge. The parties agree that the department will be named as the temporary managing conservator of the children. The mother will be named as the temporary possessory conservator of the children. We're asking the court to defer child support and medical support till further order of the court. We're asking the court to order the parties to attend a family group conference in order to develop a family plan of service that is narrowly tailored to address the reasons for removal in this case. The department has agreed to conduct home study on any relative or fictive kin identified by the mother for potential placement of the children. And then finally, Judge, the department has agreed to weekly visitation between the children and the mother for 1 hour, supervised by the department, and also asking for the court to authorize the parties to increase that visitation based on compliance with the family plan of service and agreement of the parties.
Okay, the only thing I missed was the frequency and duration of the visitation at first.
Weekly for 1 hour supervised.
Okay, thank you. I just realized that Ms. Acosta was on the phone. I put her back into the main session. Ms. Acosta, could you unmute and announce for me, please?
Irene Acosta, attorney for the children. I'm ready, Your Honor.
I've got another number that, well, they just came in and they just left. I don't know if that was the jail or not, but we're going to keep rolling. Okay, I'm going to read back the agreement just for Ms. Acosta's sake, because I don't know if she heard it. I want to make sure that we're all on the same page. The department's to be the temporary managing conservator, mother to be the temporary possessory conservator. Court will defer child support and medical support until further order of the court. Parties to hold a family group conference to develop family plans of service. A home study to be done on any relative or fictive kin identified by the mother. Mom to have weekly visitation for 1 hour and to increase as agreed. Is that the totality of it?
Yes, Judge.
Okay. Is that your understanding of the agreement, Ms. Acevedo?
It is, Judge.
All right. And Ms. Savage and Mr. Saldivar were not proceeding as to their clients today. Ms. Acosta, is that your understanding of as to the agreement?
Yes, Your Honor, it is.
Okay. Ms. Murguia, how do you pronounce your last name?
Murguia.
Murguia. Okay. I figured I was probably doing it wrong, but anyways, did you hear the agreement that Mr. McKeska and I both stated on the record?
Yes, Your Honor. Thank you.
All right. Is that the understanding you had of the agreement?
Yes, sir.
You had an opportunity to discuss that with Ms. Acevedo?
Yes, sir.
You understand what's expected of you?
Yes, Your Honor.
Did anybody force you into this agreement?
No, sir.
Did anybody make you any promises or inducements to get you to agree to it?
No, Your Honor.
Are you asking the court to approve your voluntary agreement today?
Yes.
Okay. Thank you.
Thank you.
Let me ask you while we're at it, Ms. Murguia, do you have the opportunity or the ability to pay for an attorney in this case?
No, Your Honor.
Do you have any money saved or anything that you could liquidate that would allow you to pay for an attorney?
No, sir.
All right. And are you receiving any type of governmental assistance?
Yes, sir. SNAP, WIC, and the children have Medicaid.
All right. Court will make a finding at this time that the mother is still indigent for the purposes of this hearing. Because I cannot question the fathers at this time, I'm going to continue their indigency status as well and continue Ms. Savage and Mr. Saldivar in their appointments. Ms. Acosta, well, actually, just one second. Would it be Mr. Hernandez or Ms. Burciaga giving testimony in this case?
It'd be Mr. Hernandez, Judge.
Okay. Mr. Hernandez, did you take the oath?
Yes, sir.
Okay. Did you hear the agreement stated on the record?
I heard it just now, yes.
All right. Do you believe that this agreement is in the best interest of the children?
Yes, Your Honor.
And do you believe that the children are in a placement that's safe and appropriate, meeting their needs?
Yes, Your Honor.
And are you asking the court to approve this agreement because there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home was contrary to the welfare of the child?
Yes, Your Honor.
You believe the urgent need for protection required the immediate removal of the children and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal?
Yes, Your Honor.
And do you believe this agreement is necessary and that reasonable efforts were made to enable the children to return home, but there was a substantial risk of continuing danger if they were returned home?
Yes, Your Honor.
All right. Mr. McCaska, anything else from the department?
No, Judge.
Did the parties stipulate to the reasonable efforts made in the affidavit?
Yes, Your
Mr.
Honor.
McCaska and Ms. Acosta and Ms. Acevedo?
Yes, Judge.
Yes, Judge.
Yes, Your Honor.
All right. Anything else that you want to add, Ms. Acosta?
The children are in two different placements at the moment, and so I would like family to be studied to potentially get them all together. But they're doing okay. The little one is 7 months, so it's a little more easygoing with her because she's little. The 14 and 10-year-olds are pretty vocal about wanting to go home. They're in therapy. They're seeing a therapist where they are right now. I'd like to see that continue. And that's it for now. I mean, I want to see how this case progresses. I'd like mom to get whatever assistance she needs.
Okay, thank you. How old is William?
He's 10.
He's 10?
Unless I'm getting them mixed. He's either 10 or 14. I might have them mixed.
No, he's 10. William is 10. Dylan is 14. Sorry to interrupt.
No, that's fine. Miss Greenlee, I think we've got 20. We need to have 2014 and that birth date there. Thank you. I think we've addressed anything that we needed to address as far as the agreement goes. Court will find that Miss Murguia was served by personal service July 24th, 2024. Court finds that as of today, Mr. Hutchins was served July 22nd, 2024, and Mr. Hernandez has not been served. Court is not entering any orders as to the fathers today and has granted the not readies of their attorneys respectively. The court will take up the rights of the fathers on September 10th, 2024 at 2 p.m., which is the date of our status hearing. Court will allow the parties to submit a written agreement signed by all attorneys and the parents if you come to an agreement in lieu of that adversary hearing. Court finds that the agreement of the parties is in the best interest of the children. Court will name the Department of Family Protective Services as the temporary managed conservator, name the mother as the temporary possessory conservator. Court finds there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession. for the children to remain in the home is contrary to the welfare of the children. Court finds the urgent need for protection required the immediate removal of the children. Reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal. Reasonable efforts have been made to enable the children to return home, but there's a substantial risk of continuing danger if they are returned home. Court finds the parties have stipulated to reasonable efforts in the affidavit, and the court will find based on the affidavit and testimony herein that reasonable efforts were made pursuant to the affidavit. Court will order that there be no child support or medical support at this time. They'll be deferred. Court orders the parties to attend a family group conference to develop a family plan of service for the mother that's narrowly tailored to address the concerns that brought the child or the children into care. Court will order that the parties have agreed any relative or fictive kin identified by the mother is to be studied. If there's multiple, then I'm hoping that all of you can figure out the order of precedence there. If you can't, submit it to me, we'll figure it out. Court orders that mom is to have an hour weekly visitation to increase as agreed by the parties and based on her engagement. Court finds that all parties are indigent at this time. Again, our status hearing is going to be September 10th, 2024 at 2 p.m. I have to admonish you, Ms. Murguia, that the state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for the child. In the event you cannot do so, your rights to your child are subject to restriction and or termination.
I understand, Your Honor. Thank you.
Thank you, Ms. Murguia. Anything I failed to address, Mr. McKesson?
No, Judge.
Sarah, that's us.
Okay. Thank you all for your time and your service. If there's nothing further, all parties are excused.
Thank you.
Thank you.
Thank you, Judge.
Ms. Fuller, are you covering on this case?
Yes, I'm covering for Miss Savage.
Okay, then we just don't have Ms. Acosta then, Ms. Greenlee.
I'll text her, Your Honor.
Thank you. Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department. Riley Sherrod Buckner, permanency specialist for the case.
Christy Knott, permanency supervisor with Belong.
Javier Hernandez with Family Base.
Rochelle Acevedo, attorney for the mother, Crystal Murguia. Ms. Murguia, will you please announce?
I'm so sorry, I was muted.
Could you state your name, please?
Crystal Murguia, sir, Your Honor.
Thank you.
You're welcome.
Deborah Fuller. Oh, sorry.
Go ahead.
Go ahead, Rich.
Richard Sullivan, attorney for Mr. Gabriel Hernandez. Judge, I don't see him present, but I'm ready for today.
Deborah Fuller standing in for Kathleen Savage, Your Honor, and her client, Mr. Hutchins, is in the Medina County Jail, and they were supposed to put him on, but I don't see them. But she's ready.
Thank you for covering. Ms. Acosta, can you announce when you're ready, please?
Irene Acosta for the children. I'm ready, Judge. Sorry for my tardiness.
Okay, we're just not doing announcements.
Yes.
Ms. Sherrod Buckner, your report states that the children of the suit, Marilyn, is not quite a year old yet, in a foster placement in Bexar County. William is 10, and the Bridge in Bexar County, and Dylan is also at the Bridge, and he's 14. Is that all still correct?
Yes, sir, that is.
All right, and are these placements in the best interest of the children at this time?
Yes, sir.
Are they all safe and appropriate, meeting their needs?
Yes, sir.
You're asking them to continue in these placements today?
Yes, sir.
Okay. And the children, are all the children up to date on their medical, dental, and vision checkups?
Yes, sir.
Any concerns at all that we need to discuss today?
No, sir, not at this current time.
Okay. It doesn't look like there's any medications except for Dylan is taking a couple of psychotropics at this time. Is that correct?
Yes, sir.
And is that review up to date?
Yes, sir.
All right. And how are his behaviors?
There has been a lot of behaviors at the current placement with Mr. Dillon. He has been very defiant with the staff. He also has been running away from his current placement. The San Antonio Police Department has been called on multiple occasions to also retrieve Dylan. The staff has been very lenient with Dylan, with allowing him having his time to himself. So they've been giving him curfews. He's also been putting himself at risk because he also has been climbing on the roof of the building. And then he's also been jumping the gate. And then behind the gate, there's like private property to other individuals' residents. So right now, we're not happy with his behavior, but we are in the process actually removing him from the bridge as of tomorrow, where he will be placed with family.
Okay, so then it's not in his best interest to remain at the bridge.
Not at this current time, but as of right now, that's where he still is until tomorrow.
Okay. All right. Where will he be going?
He will be going with his uncle, Mr. Murguia, who currently lives in Bexar County.
Okay. All right. Did you all hold a family group conference?
Yes, sir, we did.
And who all participated in the family group conference?
That was Miss Irina Costa, Miss Kathleen.
I meant of the parents.
Oh, Miss Murguia, Mr. Hernandez was not able to be present, and then Mr. Hutchins was not able to be present.
Okay, so only the mom participated in the creation of the plan.
That is correct.
And has anybody reviewed and signed it?
Miss Murguia has reviewed her service plan, and then Mr. Hutchins, I did go over his family plan of service, so he did receive a copy of it. So that was his signature with me giving him his service plan.
Mr. Hutchins?
Yes, sir.
Okay. Did Miss Murguia sign it?
Yes, sir. She
Okay.
did.
So then you haven't received a signature or a review from Mr. Hernandez?
Correct.
All right. Do they all three have a copy of their plan?
Yes, sir.
Okay. Have you had a chance to meet with Mr. Hernandez?
We did meet on August 22nd. However, I was not able to have a notary on site at that particular time because we did wait, but I understood that he had to leave. That was the only time, but we have been texting, and we are supposed to meet tomorrow, pending when he do get out of his domestic violence classes.
Okay. This family plans and service that you created narrowly tailored to address the concerns that brought the child into care or the children into care?
Yes, sir.
Are they on file with the court, with the clerk?
Yes, sir.
Are they in the best interest of the children?
Yes, sir. At this current time. Yes, sir.
You asking the court to make the family plans and service orders of the court today?
Yes, sir.
Okay. Can you briefly spell out which major services you're going to have the parents do throughout the course of this case? Are you requesting that them do?
At this current time, we would like for Ms. Murguia to engage in her substance abuse classes. And then following, we would like for her to attend psychological. And then after that, we would like for her to engage in parenting classes as well, following by individual counseling. And then I do believe a psychiatric assessment to also monitor her medication as well. That also would include her testing randomly on UAs and hair tests as well for her. I recently was given information that she and Mr. Hutchins, it is in a relationship. So following that, she will be required to complete couples counseling as well.
All right. And what about Mr. Hutchins?
For Mr. Hutchins, he will also complete a psychological, and that will also be pending recommendations, and then followed by parenting classes. We will also like for him to engage in random UA and also hair tests. We will also like for him, if he is taking any medication, also followed by psychiatric evaluation to monitor any and all medication he's also taking, and then also engage in individual counseling as well. And then followed by anger management as well. For both parents, I apologize for Ms. Murguia as well.
Okay. And Mr. Hernandez?
Yes, sir. Mr. Hernandez, he was given a basic family planning service because I wasn't able to do a very thorough, but he did say we can do that as the time progressed. But for him, we are asking for parenting classes, individual counseling, a psychological, and then also participate in random UA and hair tests.
And you believe that all of these services are necessary and appropriate?
Yes, sir.
Okay. As of today, is it safe to return the children to any parent in this case?
No, sir.
As of today, has any parent fully addressed the concerns that brought the children into care?
No, sir, not at this current time.
Is there any Indian child heritage in this case?
No, sir.
And did you all develop a permanency goal at your family group conference?
Yes, sir.
And what is that?
At this current time, the primary goal is family reunification.
And are any of the parents visiting?
Yes, sir. At this current time, Ms. Murguia does get weekly Wednesday visits from 4 to 5 in San Antonio at our Children Matter location. Pending Mr. Hudson's release date, he will also engage in parent-child visits as well on Wednesdays, right after Ms. Murguia from 5 to 6.
Okay. Are you asking for any changes to the visitation plan today?
No, sir, not at this current time.
Are the visitations appropriate?
Yes, sir.
Ms. Thompson, do you have any questions for Ms. Sherrod-Buckner?
I do not, Your Honor.
Ms. Acevedo?
Thank you, Judge. Ms. Red-Buckner, with regard to, well, let me start with the placement. You indicated that Dylan is going to move placements, correct?
Both children, William and Dylan, sorry.
I'm sorry, William and Dylan will be moved?
Yes, ma'am.
Okay, and the baby?
No, ma'am, she will not be moved at this current time.
Why not?
That home study has not been done. I did speak to Ms. Murguia's sister, Ms. Vanessa, so we are scheduled for me to go out on the 20th.
I'm sorry, you said the 20th?
Yes, yes, ma'am.
Okay, and this placement is still in Bexar County?
Yes, ma'am. The new placement, yes, ma'am.
Will the children have to change schools?
Yes, ma'am, because right now where they're going to school is online at the bridge. So when they do transfer or be removed and placed with the uncle, that will be actually going to the middle school and the high school.
Do you know what area they live in?
I'm sorry, can you repeat that?
Do you know what area of town they live in, like north, east, south?
I do believe it is part of on the southeast side of San Antonio, but I'm not aware of the school because I know the uncle just moved into the area.
Okay, because you indicated all visitations are going to be in Bexar County. Is there going to be any changes to that?
For the visits for mom?
Yes.
No, ma'am. At this current time, mom was aware that her visits will remain supervised by Children Matter, which she was okay with.
Okay, well, and it's not necessarily the supervision. Has she indicated that she's having transportation issues?
Yes, ma'am, in the beginning. Yes, ma'am.
Okay, and is it possible to get these visits supervised in your local county?
Again, I can see if there is another agency that we work with that will be willing to house that visit. Yes, ma'am, I can look and see.
Okay, well, and I think what will have to be reconciled is where would the baby go? Do you know what county?
It'll be Medina County. If the home study is approved, for the sister, it will be Medina County.
Okay, and do you anticipate where those, I know we're talking in theory, but where would those visitations be?
Also in San Antonio, pending if I'm able to find a different agency that's able to meet with have a facility within the middle that mom can have her visits.
Okay. Up to date, has mom been compliant with all of her UAs?
At this current time, yes. Mom did receive a notice to go on the 5th. I did look and that has not come back yet. It is in the system as a no-show, but I have not spoken to mom about it yet.
Okay, and additionally, where are you sending her for her UAs?
Right now it is in Parasol. Because when it comes to when we do send our parents, we have to have the location that's clear, that is the the closest to them. But right now she is going to Parasol, which she did ask me if she can go somewhere closer. But right now it's San Antonio, which she did let me know that she does not like driving to San Antonio.
Okay, and do you not have any local UA providers?
The only ones that I see in our system is either the Parasol location, the Uvalde location, and I do believe the Texas department, I think it's like a UA, which is like another 30 minutes. And that's within the radius of like a 20-mile radius.
Okay. Can you possibly look to see if there's anything closer that y'all, with a provider that y'all contract with?
Absolutely, yes, ma'am.
Okay. With regard to the the incidents with Dylan, have you been keeping mom informed of these incidences?
Yes, ma'am, she is aware.
And I mean in a timely fashion, or how long has it taken you to let her know what's going on?
I have not spoken to her today because I did get one of the incidents from today, but the previous incident, mom is aware technically within that same day or the next day.
Okay. Again, up to date, has mom been cooperative?
Yes, ma'am.
Okay. She has started a lot of her service plan?
That is correct.
Okay. And in your review, did you feel like she fully understood everything that's being asked of the department?
Yes, ma'am.
No questions about the service plan?
No, ma'am.
Okay, thank you. I'll pass, Judge.
Mr. Saldivar.
Yes. Did Mr. Hernandez get a copy of his service plan?
Yes, sir. The only thing I did not provide him a copy was the removal affidavit because he didn't sign the waiver of service. But he did let me know he had already received a copy from Mr. Hernandez. Well, the family-based Mr. Hernandez.
Okay. And so did you go over the plan of service with him?
Yes, the only thing that we was waiting on, he did let me know he already had services that he was already doing for probation. I did explain to him I can see if we can utilize those services, but that was something I would have to talk to the attorneys about. But he also have to provide me with his probation officer number, which he has not provided me with yet.
Okay. As far as objection to any of the services, do you know if he was in agreement to all the services or was he objecting to any of the services?
No, his thing was he just wanted, when I spoke to him, he said he wanted to talk to his attorney first because he did explain that he did have a lot on his plate. And then adding the family plan on top of that, he felt like he couldn't commit to that. But when I am scheduled to meet with him tomorrow to answer any questions he might have, and then possibly get him to sign the waiver of service. He just was a little iffy about signing any documentation.
Gotcha. Okay. And as far as visitation, has he been able to visit at all?
No, sir, he has not.
Okay. Will visits be offered to Mr. Hernandez?
Yes, pending him signing the waiver of service. I did ask him if he wanted visit. He said yes, he did. But he just said right now he would just have to get a lot of his classes aligned so he can be able to attend those visits.
Okay. So all the department wants to see for now to start the visitation is waiver of service. Is that right?
Yes, and then I would like for him to at least send me his probation officer information so I can know what classes he's actually taken through probation and I can see if that aligns with our services as well. And then I would also like for him to take a random UA and also a hair test as well.
Okay. But I understand that that's a part of his services, but just to get the visit started, you just want to see the waiver signed so far. Is that correct?
He actually need to get fully engaged with the family planning service, and then I can staff for him having visits.
Okay, pass the witness, Judge.
Ms. Fuller.
Ms. Buckner, in regards to Mr. Hutchins, have you met with him?
Yes, ma'am. I met with him last Tuesday.
And he's agreed to the services?
Yes.
And did he fill out a child placement resource form?
No, ma'am. Not to my knowledge. Not with me. No, ma'am.
Okay. But is he asking the department to place Marilyn with Vanessa Wechter?
I believe it's Wetcher. Yes, ma'am. He is aware.
And is there a home study? Where are we at with the home study?
So as of right now, I'm only doing the preliminary home study, due to Ms. Murguia's sister. She does work a lot. So I did talk to her, but right now she did let me know she don't know if the living portion for where the children are currently staying will be acceptable. So I told her I will be staffing it with my supervisor and go out to the home, making sure they have running water, electricity, and things like that. Because she also have 3 children herself.
Okay, but I mean, this is the status hearing, and was that requested at the initial adversary hearing?
I do believe so, yes, ma'am. But due to the children, Dylan and William, I didn't get to finish it, but it was in the process of being completed. But the other children are in an emergency placement. So, and I did explain to Miss Murguia and her family that I wanted to place them first due to the 90-day of them being in the placement. So I wanted to get that done first so I can be able to start the home study for Miss Vanessa Wetcher.
And in regards to William, the child, didn't Mr. Hutchins request that his mother, Catherine Hutchins, be studied for placement of his oldest child, William?
Yes, ma'am. I did have that conversation with Mr. William Sr. I did explain to him when reading the affidavit.
My question was, did he ask you to study his mother for placement of his child, William?
Yes, ma'am.
And he's being placed with someone he's not related to, correct? Although he's with a sibling.
Yes, but he's being placed with his uncle. Yes.
That's not his uncle. You said it was Mr. Hernandez's brother, right?
I think I'm getting confused. Can you repeat the question?
The uncle that Dylan and William are being placed with, who is that uncle related to?
That's Miss Crystal's brother.
Oh, okay. So it's not Mr. Hernandez's relatives.
No, ma'am. That's Miss Murguia's family.
Okay.
Just.
And have you talked to Mr. Hutchins about that? Is he in agreement with that?
Yes, ma'am.
Okay. And do you have any idea when he will be released from Medina County Jail?
Not at this current time, no, ma'am.
And you did indicate that he will have weekly visitation at Children's Matters once he's released?
That is correct.
And what do you want to see from him immediately upon release?
Yes, ma'am. So I would also like for him to engage in an Ozark assessment, followed by getting him engaged in domestic violence classes, and then followed by anger management classes, also with him completing a psychological assessment. And then I would like for him to also
Ms. Shore-Buckner, what do you want to see from him first when he gets out of jail? What is there?
I would like for him to complete the Ozark assessment. Yes, ma'am.
Okay. And do you know if he'll be on probation and have probation requirements?
When I did spoke to him, he did say once he's released, his case will be dismissed.
Okay. And so at this time, he does not want his mother studied for William. And you've confirmed that with him?
So when I spoke to him, he do want his mother to be studied, but he is aware, which he agreed that we place William first, Jr., and then we would do the home study for his mother.
Okay, so you're still planning on doing it?
For Mr. Hutchins' mother?
Yes.
Not at this current time, no, ma'am, which he is aware.
Okay, I'll pass the witness.
Any other questions for this witness?
I have a few questions, Judge. Ms. Shard-Buckner, with regard to visits, is it your understanding that the visits between Ms. Murguia and Mr. Hutchins, those are going to be separate, correct?
That is correct.
Okay, and those are going to be separate for the foreseeable future until the case progresses, correct? Given the allegations and the reason this case came into existence?
Yes.
Okay. With regard to placement, it's Dylan and William are placed together, correct?
Yes.
And do you think that it's in the best interest of the kids to have as many of them together as possible at this point?
If possible, yes.
Okay. So if we can have Dylan and William in a placement together, that's better than having Dylan in a placement, William in a separate placement, and Marilyn in a separate placement, correct?
Yes, ma'am.
Okay. When Dylan and William are moved, is Dylan going to continue, are they going to continue with the therapies that they were being provided at the bridge?
No, ma'am. The placement will be responsible to ensuring that Dylan is engaged in enrolled in therapy.
Okay, and how are you going to assist with that?
Me and the uncle has been talking about different agencies that can possibly do virtual therapy session for William and Dylan. But it's just more so of the time because he does work. So it's just a matter of us actually looking at different agencies that will be able to do virtual.
And with regard to,
sorry,
I apologize. With regard to school, how will you be assisting the placement in registering the children for school?
So I do have to pick up the withdrawal paperwork from the previous school to actually show the new school that they have been enrolled. I know that the uncle did say they can provide transportation back and forth due to his current wife does not work. So it'd just be a matter of actually us looking within the school district that can actually take the boys.
Okay, and will you be doing that after they've been placed? So on Thursday?
It'll be Wednesday, so I'm hoping to have the boys registered within 24 hours.
So by Friday, they should be set to they should be registered in school.
Hopefully so, yes, ma'am.
Okay. Are all three children having their visits with the parents or with the mother together?
Yes, ma'am.
Okay, and is that going to continue?
Yes.
Okay. Are there any concerns with the visits?
Not at this current time, no, ma'am.
Is there anything that any of the children need right now?
No, ma'am. All of their needs are being addressed by their current placement.
Okay, I'll pass the witness, Judge.
We're about out of time. Does anybody have anything else pressing that I need to hear?
I'm sorry, may I speak? Pearlie, on Friday, I did go to peer.
Hang on.
Sorry.
Just a minute, Ms. Murguia. Ms. Ford, did you have something?
Well, Ms. Savage had said that her client was in agreement with services and but that he wanted his mother studied for his son William, and then he wanted Vanessa Wechter studied for the baby. And so I just wanted to make sure that was on the record and that he would be getting the weekly visitation once he is released from Medina County Jail.
Okay. Ms. Murguia, are you just wanting to give the court information or do you have a question?
No, I'm sorry. I just wanted to inform Mrs. Buckner that I did go on Friday. I have my donor copy, so I don't want it to show that I was a no-show to my UA.
Okay. Y'all can discuss that after the hearing. Thank you.
Thank you, Your Honor.
Okay.
Judge, I just have a quick request for Mr. Hernandez.
Go ahead.
Judge, the visits are going to be supervised. I ask that they start immediately. I believe he wants to comply with the department. He's being monitored by probation right now. He did appear at I think at the 262 hearing, Judge. So I don't want them to be contingent on him signing anything. I think he needs a bond with his child, and they can be supervised by the department, and then they could be increased if he complies. So I'm just asking that those visits start immediately.
Your Honor, I have a couple of requests on behalf of the children.
When we had our adversary hearing, we addressed the visitation of the mother. We didn't address the visitation of either fathers. Is there some reason why we can't start visitation for both fathers once they're both available?
Your Honor, I would ask that visitation be contingent upon Dylan wanting visits. It's my understanding he doesn't have a relationship with his father, and I know that he's struggling just to have visits with his mother right now because of everything that's happened, and I don't want to force something on him that he doesn't want. So I think ordering visits, but making them contingent upon whether or not he actually wants them. I don't want him to
but I think she's too old.
any more of a
I'm getting noise from somewhere.
into any more of a downward spiral, or to have him have any other behaviors. I know he doesn't want to have visits with Mr. Hutchins, which is why I've requested that the visits be separate between Ms. Murguia and the kids and Mr. Hutchinson, the kids, because Dylan does want to have visits with his siblings, but he doesn't want to have them collectively with the parents. And so he goes to the visits. William does want to have visits, and the baby does want to have visits. I mean, appear to be doing fine with the visits, but Dylan in particular is not, he's struggling. So he goes to the visits so that he can see his sister, but not necessarily because he wants to go to a parent visit. But I'm glad that they're moving to family. I know that that's something that has been requested and is something he's wanted and that William has wanted. So, and I would also request that family members be studied for the baby as soon as possible.
I think I've addressed all that in my notes. For the purposes of the status hearing, the court finds there's no any child heritage in this case. Court finds that the permanency goal is family reunification. Court finds that the placements of William and Marilyn at this time are safe and appropriate, meeting their needs and in their best interest to continue. Court finds that Dylan's placement is not in his best interest to continue. But my understanding is that Dylan and William are going to be moved tomorrow to a relative placement. So let's make sure that transition goes as smooth as possible. Court finds that all children are up to date on their medical, dental, and vision checkups. Dylan is receiving psychotropic medications, and those are up to date, although his behaviors are very questionable right now, and we don't know exactly why, so we just need to continue to monitor that. Court finds that as of right now, their educational needs are not being met. I'm going to order belong to make sure that Dylan and William are enrolled in school by Friday. Court finds that parties held a family group conference and developed family plans of service that the mother participated in. Court finds that Ms. Murguia has reviewed and signed her plan and has a copy of it. Court finds that Mr. Hernandez did not sign his plan but has a copy of it, and that Ms. Sherrod Buckner has met with Mr. Hernandez. Court finds that Mr. Hutchins signed his plan and has a copy of it. I don't know if it's been reviewed with him in detail, but if not, it needs to be. Court finds that the plans are on file, and I'm going to make those orders orders of the court find they're in the best interest of the children. I'm going to continue the current visitation schedule with the mother and find that that's in the best interest of the children. I'm going to order visitation with the fathers contingent upon therapist recommendation. And I'm going to make the visits between the mother and the fathers all to be separate. Here's what I have to say about Dylan. He's obviously having some issues right now. I don't want to make it worse, but I also don't want to overlook the fact that not having any contact with his father for, was he 15 years old? I don't know how long it's been. Maybe that's part of the issue. So I want a therapist involved to figure out what's going on there and then to determine whenever it's appropriate for Dylan to have visitation with his father. I don't want to make it contingent upon whether Dylan wants it alone, because he may not even understand what's going on. And that's why I want a professional involved. So contingent upon therapist recommendation, and that therapist working with Dylan can figure out what Dylan wants and what would be best for Dylan. And that's where I want to leave it. If that doesn't work out, or there's some issue, Ms. Acosta, then just bring it to the court's attention and we'll figure something else out. I'm just concerned about leaving it all in his hands at this time. There's a lot going on. Gonna order belong to study the relatives of Mr. Hutchins, and I'm going to distribute a discovery control plan and a pretrial scheduling order. Please review those for dates and times of discovery and future hearings. Next hearing is going to be initial permanency hearing, December the 10th, 2024 at 10:30. December 10th, 2024 at 10:30. I'll find that the parents are cooperating at this point in time. And based on what I've heard today, I'm going to find that all parents remain indigent at this time and that continue the attorneys in their appointments. We are 10 minutes over time. Is there anything that I still need to address?
No, Your Honor.
Okay. Thank you all for your time and your service, Ms. Murguia. Good luck to you. And if nothing further, all parties are excused.
Thank you, Your Honor.
Thank you, Judge.
For Judicial District Court of Medina County. The court is broadcasting via Zoom and YouTube from the courthouse in Kendall County. Are there any objections?
No objection, Judge.
No objection, Your Honor.
All right, Mr. McCaskill, would you please begin the announcements?
Yes, Judge Drake McCaskill, attorney for the department. Mr. Sauce, can you announce, please?
Krista Rosales, investigator for the department.
Alexandra Vanderbilt, investigation supervisor for Ms. Rosales.
Richard Saldivar, attorney for the children, ready?
Rochelle Acevedo for the mother, Renee Blackwood. She's present, Judge, but I am announcing not ready.
Ms. Blackwood, would you please unmute and announce?
Hi, Renee Blackwood here. Are you able to hear me?
Yes, ma'am.
Okay.
All right, Ms. Rosales and Ms. Blackwood, would you both please raise your right hands? Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Thank you. We are here for a court-ordered services case. Ms. Acevedo has announced not ready. And what's the reason for the not ready announcement?
Judge, my client has not been served. I spoke to her for the first time briefly yesterday. That was a telephonic communication, Judge, so it was difficult. She has not actually seen the pleadings in this case. She hasn't seen the affidavit. She does want to obviously have those in hand, review them, and discuss possibly having a contested hearing, Judge. So we need time to prepare for that.
All right. Response?
Judge, I'm not necessarily opposed to Ms. Acevedo's not ready. I know based on communications that were ongoing this morning between the department and law enforcement agencies that there hadn't been service, that attempts were made, but service hadn't been perfected. So I can agree with Ms. Acevedo to the standpoint that Ms. Blackwood hasn't been served and doesn't have a copy of those pleadings. So if we are going to reset, Judge, I just ask that it be a relatively short reset and that we have enough time to be able to have a contested hearing for that reset so we don't have to push this matter any further.
Mr. Saldivar?
No objection, Your Honor. I don't believe the mom's been served. I was able to see the children yesterday. They look happy and healthy. And they were at the father's home, and so I don't object to the reset, Judge.
All right, then. The court will grant Ms. Acevedo's not ready. And Ms. Rosales, I know Mr. Saldivar is fine with how things are for the children right now. Anything you want to add? You're comfortable with the children at this time and placement?
Yes, Your Honor.
And Judge, I know that the department has been having trouble being able to lay eyes on the kids and have a face-to-face contact with the children. So I just asked the court to admonish Ms. Blackwood that during this reset period, she be forthcoming with the children's location and allow the department to have access and a face-to-face visit with the kids.
Okay, and then has mom been served?
No, Judge, she hasn't.
All right, Ms. Acevedo, is your client willing to enter an appearance today?
Yes, Judge.
Okay. Okay, then I'm going to grant you some more time, Ms. Blackwood, to work with Ms. Acevedo and prepare for this and determine whether or not you want to contest it. I'm going to give you till August 13th, 2024 at 3:30. That's August 13th, 2024 at 3:30. That'll be by Zoom, be by the same exact link that we're on today.
Okay.
You'll just do the same thing that you're doing now, log in about 3:25 or so. We'll get going. I'm sure you're going to be talking to Ms. Acevedo between now and then anyways.
Yes.
I also am going to make sure you understand, as Mr. McKesko requested, that that's about 2 weeks. So the department is going to want to just check in and make sure that everything's going fine with the kids.
Sir,
So
I'm sorry, I didn't mean to interrupt you. So personally, I've complied with pretty much everything except for the services because I looked into it. Oh gosh, what happened? Okay,
I can
I'm
still
sorry. I
hear
don't
and see
know.
you.
I'm sorry. Did you hear me or no?
I did.
Okay. I'm sorry. I just got an Amber Alert on my phone and it messed everything up.
Okay, well, let me just stop you real quick because I want to give you the opportunity to talk to your attorney before you say anything else here on the record. Okay. The
Okay.
only thing I want you to know is that it's in a court ordered services case, or we call required participation. What the department's asking for is for you to participate in some services that they think will alleviate any risks of abuse or neglect that may have occurred or may occur in the future.
Okay.
And I have to make the decision on whether or not I'm going to grant their request to do that.
Yes, sir.
If you're not cooperative with them and just let them lay eyes on the children and make sure everybody's okay between now and August 13th, then that may work for or against you. I don't know. I can't tell you how. All I can tell you is they're going to, well, hang on. They're going to come to me on the 13th and they're going to tell me, Your Honor, we asked you to allow her to just grant us access to the children and she didn't allow it. Maybe you have good reason for that. Maybe you don't. I'm not making a judgment on that right now. I'm just telling you, they've asked me to tell you this and I'm telling you.
Yes, sir.
So between now and the 13th, they're going to be coming, checking on the children. And it's up to you whether or not you're going to want to cooperate with them. But whatever you do, it's going to come back to me on the 13th. I just want to make sure you're aware of that. Okay.
Yes, sir.
I would strongly encourage you to talk to your attorney, Miss Acevedo. She's worked a lot of these cases. She knows what she's doing and she can give you the appropriate advice to help you determine how you want to proceed. Okay.
Yes, sir.
All right. And I'm going to keep you from saying anything else on the record to protect you because I want you to talk to your attorney first. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay, then I'll see you all August 13th, 2024 at 3:30. Thank you all for your time and your service. Nothing further. All parties are excused. Broadcasting by Zoom and some of you at courthouse in Kendall County, Texas. Are there any objections?
No, Judge.
Mr. McKeska, would you please begin the announcements?
Yes, Judge. Jeremy Pesca, attorney for the department.
Rosales, investigator for the department.
Alexandra Vanderbilt, Ms. Rosales' supervisor.
Christy Cannot, permanency supervisor, observing.
Kathleen Savage, standing in for Marco Cabrera, the attorney for the respondent father, Mr. Ruiz. He's present, but we're going to announce not ready, Your Honor, no contact prior to.
Irene Acosta, attorney for the mother. I'm announcing not ready. I haven't had contact with Ms. Mejia previously, aside from one email.
Alana Pearsall, attorney and guardian ad litem for the child. I'm ready.
Permanency specialist observing.
All right. We've got two announcements of not ready due to no contact. I've got a stand-in attorney for an adversary hearing. I'm inclined to grant a reset. Any opposition to it?
No, Your Honor.
Your Honor, I don't have any opposition to a reset. I am asking that the department be ordered to immediately get a full evaluation of the child by a pediatric developmental specialist. I'm concerned there's some severe undiagnosed medical conditions that this child has, so I want to make sure we get a full eval done as soon as possible. But I have no objections to the reset.
Any problem from anybody else with a full evaluation of the child?
No specific objection, John.
I think if the ad litem has some concerns, and we're going to move this back to give the parents some time, an evaluation is probably appropriate if it's a best interest issue. We're still under emergency jurisdiction. All right, this is going to be August 13th at 4 p.m. We're very full that day. We're very full this month. So that'll be our reset time and date. August 13th, 2024 at 4 p.m. Ms. Mejia and Mr. Ruiz, I'm going to put you both in what's called a breakout room with your attorneys for a moment. In the case of Mr. Ruiz, you'll be in a breakout room with the person who's standing in for your attorney today. She will give you his number. When we come back on August 13th, I will have expected you to, or will expect you to have talked to your attorney and prepared for the case. I'm not going to reset it because you haven't reached out to your attorney and prepared. This is the opportunity I'm giving you to do that. I'm giving you 14 days to get in touch with your attorney and to prepare on whether or not you want to make an agreement or you want to have a contested hearing. So I'll see you all back 8/13/2024 at 4 p.m. This is an order to appear. It's the only notice anybody's going to get. So mom and dad, if you're hearing this, it means I'm ordering you to be there. I'm now going to put Ms. Savage, I'm moving you to room 2 with Mr. Ruiz. All right, he's in there. That room is open. And Miss Acosta, I'm putting you in room 3 with Miss Mejia if you need it. Y'all are free to go whenever you're done.
Thank you,
Thank you,
Judge.
Judge.
You're welcome. All parties are excused.